Hi, everyone. Sorry for a little bit of a slow start today while we dealt with the typical technical difficulties. Thanks for joining me. We've got a big crowd today, so please feel free to submit questions. If I don't get to them during the session, I will try to follow up and get to them later. But I really appreciate you joining today. It's great to see everyone. Today, we're going to talk about sweepstakes, contests, and giveaways as we're seeing them sort of develop in the current era, shall we say. There's lots of new types of promotions that we're always seeing develop. And so my thought was to talk about both some of the basics, but then a lot of the new stuff that we have been seeing in the past year or two, a few of the new cases and some of the new concepts as well. And some of the issues that they raise in sort of both the traditional, how the traditional concepts apply, and then also some of the new issues and legal tricks that they may trigger. So here's an agenda. I'm not going to spend a lot of time explaining it. You'll see it as it comes up, but to the extent I tend to pack a lot of detail into my slides, so to the extent that it can serve as sort of a table of contents later, it may be helpful. These will be emailed out, these slides, so you can keep an eye out. As you can imagine, sweepstakes continue to be heavily regulated in 2022. That's not a surprise, I think, to anyone. This is one of the most heavily regulated areas. And we see regulations coming from sort of all directions in the federal and state jurisdictions. One of the federal agencies, we often think about state laws here. The states tend to be, the state laws in this area tend to be very specific, but we had a reminder from the FCC that they're regulating too. The FCC tends to regulate, the broadcast licensees, so TV stations, radio, that sort of thing, and those who work with them, of course, so advertisers who work with them. And so they have the contest rule, which regulates both what goes in disclosures in broadcast advertising, and then generally making sure that sweepstakes and contests that are run on broadcast advertising or on broadcast channels are run in a deceptive and non-misleading way. So they regulate in that context. The contest rule says essentially, here's what you need to disclose in your rules and in your advertising. The contest rule was modified a few years ago to say that you can also disclose online and then refer people to where they can find the rules and the disclosures online. But recently, there was a case brought against iHeartRadio, finding that iHeartRadio had violated the contest rule, and in particular, that they'd failed to conduct their contest fairly and substantially as represented to the public. What had happened was that iHeartRadio had gone through the sweepstakes and then picked a winner and just determined that the winner wasn't eligible, which was inconsistent with eligibility as defined in the rules. Then they failed to keep the rules posted on the website for 30 days beyond the end of the date of the program, which is required in the contest rule. And so essentially, they weren't doing a good job posting their rules. They weren't doing a good job following their own rules. And this is sort of a reminder to, contest and sweepstakes sponsors that you got to follow your rules. You got to post your rules. If you don't, you can get in trouble. I think there's sometimes a tendency on the part of sponsors to say, well, if we just have the rules and we don't really post them, or we post them later, is that a problem? And the fact is that yes, it is. You can't bind people to your rules if you're not making them clear and conspicuous, which is one of the sort of basic principles of advertising law, above and beyond even just sweepstakes. Another interesting finding from the FCC there was that a complaining party does not need to be a qualified contestant in order to have standing to complain, which I think is something that goes into the risk calculus of a lot of companies running sweepstakes. Oh, well, we can make this change. We can make this change to eligibility, whatever, because who's going to complain anyway? They didn't win. There's no injury. They don't have standing. And that's just not the case. It doesn't matter whether there's a money injury necessarily in a regulatory case. May make a difference in a class action in terms of how the how the money is figured out. But certainly in a regulatory action, the regulator is not particularly going to care. As far as they're concerned, all consumers are injured if you don't run something that is fair and non-deceptive. We had a question as to whether the obligation to provide a winners list applies only to sweepstakes with registration and bonding requirements. Certainly the obligation to provide a list to the state, Florida, New York, and the like, is going to apply in that case. But there are states that have posting requirements, and you'd have to refer back there to see which states there are that may have those regardless of registration. So other states that we've just seen have new cases here. In 2019, there was a big case involving NextGen Inc., which was a company that sent mailers informing companies that they had won, or consumers rather, that they'd won, but they'd need to pay to collect a prize. This is a classic scheme. There were other mailers that were disguised as newsletter subscriptions or games of skill, all which involved a fee and an unsolvable puzzle. We've seen mailers for a long time that are deceptive and misleading. They're regulated under the postal rules, the Deceptive Mail Prevention and Enforcement Act. But what's interesting about this one is just how large the settlement was. $21 million in cash, plus a suspended settlement that'll be triggered if there's further deceptive activities or judgments of $114.7 million. So, the FTC certainly has been pursuing very large settlements lately in multiple areas, but this is sort of emblematic of that trend. And, this is something to take seriously. Another case, Indiana versus Hopkins and Raines, involving similar mailers. And again, we're seeing these cases in the states at the FTC, and also sort of in a lot of COVID-oriented claims, even in the sweepstakes context. So a lot of activity overall in terms of cases involving sweepstakes. To talk about sort of generally, how do we review prize promotions, fitting, any of the promotions you're doing into sort of the legal review context, where somebody comes to you, says, hey, we want to run a giveaway. Can we do it? Whenever you're looking at different types of giveaway concepts, it's helpful to keep in mind that, generally speaking, any of these promotions, you want to look at, are they an illegal lottery, or are they one of the types of promotions that are an exception to these criminal gambling and lottery laws? So promotional sweepstakes are a type of exception to the criminal lottery and gambling laws. The same goes for fantasy sports or charitable raffles, which are, a very narrow category of giveaways where you're allowed to charge, but really only nonprofits can do them. So if you don't have a promotion that falls within that exception, then it's probably illegal. When you're asking yourself, do I have an illegal lottery? You want to look at whether those three elements are present for a lottery. Do you have a prize, something of value that you're giving away? Are you determining the winners based on chance? And do the participants have to submit consideration? Consideration being, generally that law school concept that, for I think most of the people here attending are lawyers, but not all. The idea that it's something of value you must submit. Generally, in most states, we're talking about a purchase or a payment that you must submit to participate. But that's not true in all states, first of all. In some states, and not a significant number, consideration can be non-monetary. And states are sort of all over the map when it comes to non-monetary consideration. There are a few states that say even a visit to a store can be non-monetary consideration. Generally speaking, it's something more than that. Do they have to complete a scavenger hunt that involves multiple visits to different places? Do they have to pay for a text message? Are they being asked to complete a lengthy survey versus, a short couple of questions? Being asked to create significant user-generated content, which we'll talk about, could be consideration. Something like just snapping a photo on your iPhone is sort of one of those up in the air things. We're seeing an increasing number of sweepstakes that ask people to just snap a photo and submit it to enter. And, if you're just asking them to do that and you're not asking for the intellectual property rights, maybe, but it hasn't really been tested. So this idea of consideration, it's also important to understand that even something that you're asking them to pay after they enter, we're giving you the hotel, but you have to pay for the air tickets. Well, certainly if you're not disclosing that fact, then you could be getting yourself into hot water when the winner finds out that they have to pay in order to redeem their prize. So it's important to be thoughtful, even if you're not asking them to pay to enter, but you're asking them to pay to redeem their prize. When we talk about the federal and the state laws that are regulating sweepstakes and other giveaways, it's very important, even if it's not a sweepstakes and it's just something like a free gift or the like. Sweepstakes tend to have fairly specific, often extensive rules that talk about what needs to go in the rules. For example, you need to put eligibility requirements in, you need to put the start and end dates, things like that. The material terms must be disclosed in the rules, typically in the advertising as well. Florida law has, of course, a specific registration requirement similar to New York and also to Rhode Island for sweepstakes that are run through retail stores or outlets. In Florida and New York, when the total value of all prizes to be given away is more than $5,000, you must register and get a special type of sweepstakes bond for the total value of the prizes, or open what's called a surety account, and then file with the states 30 days in advance for New York, although they're kind of loosey-goosey about that, and 7 days in advance for Florida. With Rhode Island, you don't have to bond, but you do have to register. But so Florida actually has a regulation that describes what kind of material terms you need to include in advertising for sweepstakes, and it provides a pretty good rule of thumb for what you should be disclosing in your advertising for sweepstakes. Although, states can vary, and that's actually one of the most frustrating things about this area, is that just because you're following the rules of one state, it doesn't mean that you're following the rules of every state. That being said, Florida's a pretty good rule of thumb. But each state, some states are very general, but there are a number of different states that are very specific about what must be in the rules. There's also federal laws. We talked about the contest rule. I mentioned the postal rules that talk about, similarly, what must be in the rules. The postal rule adds a requirement that you must allow people to opt out of receiving future sweepstakes mailings. And then additionally, the social media sites, which we'll talk about a little bit later, also have some disclosures they require, typically a release. So things that you need to understand in terms of what's required. There's also just the stuff that's a good idea to include in your rules. Things like, a disclaimer of liability for you as the sponsor, as well as links to your privacy policy or the right to modify the rules if something goes wrong, which we'll talk about a little more in a second. As I mentioned, then you just want to think about what's clear and conspicuous when you're disclosing the rules, or in particular, you do want to be including these material terms, as I mentioned, in advertising. With those, you want to follow general rules as to what's clear and conspicuous. The FTC has what we call the 4 Ps for what is clear and conspicuous. Is it close to the advertising? Is it proximate to sort of the place where you're asking people to enter, or where you're, you've included the call to action describing enter to win or enter for a chance to win, ideally. Are you making it sufficiently contrasting with the background so that people can find it? It's not in gray text, but it in black or white, so that it's contrasting, things like that. You do want to follow those rules for clear and conspicuous disclosures. Additionally, you do need to be posting those rules in a way that people can find them, whether it's online for online sweepstakes or in store if people are able to enter in store. And keep in mind that winners of prizes worth more than $600 are going to owe taxes on them, so that you as the sponsor will be responsible for sending them a IRS form 1099 the following January after awarding the prize, so that they will be able to pay those taxes. So we mentioned consideration, actually. This slide, I've talked about most of this. I jumped ahead a little bit, but this slide does include a list of the states that specify that non-monetary consideration is illegal. So something to refer back to. I know somebody asked, again, we will be sending these out to people, so no worries there. So just to keep that. In terms of consideration, one thing to consider, if you do have consideration in a sweepstakes, one very common solve for that is the idea of providing a free alternative method of entry. The most common free alternative method of entry that I think anybody who's ever read the fine print has probably seen is the idea of a 3x5 card. Fill out a 3x5 card, handwritten, and send it to us at Post Office Box X. Typically, that will provide a solve for the consideration problem when you have it. However, it's important to keep in mind that first and foremost, whoever uses the free alternative method of entry must be given equal dignity in terms of the opportunity to enter and the opportunity to win. So if you're giving people who are entering via the purchase method of entry an unlimited number of entries, you have to do the same with the free alternative method of entries. Often what people will end up doing is capping both in some way based on realistically the number of purchases people are expected to make of a specific product or something like that. To the extent that you want to do something where it takes some additional or effort to enter via the free method, you just need to be realistic about how much effort is involved. It's been found that a stamp is fine in terms of a payment, but that's about where we've got agreement on what's okay. The internet or what people are paying for the internet is okay as well. But you have to keep in mind if there are costs involved in the free method, that can be touchy. So you need to consider that, make sure that people are getting a reasonable opportunity to enter for free, and then you have to disclose it again clearly and conspicuously, not just buried in the rules, but in advertising. And this is somewhere where the New York Attorney General in particular has brought a number of cases against prominent sellers like CVS or H&R Block over the years. And in addition, there's currently an ongoing class action against a crypto seller who ran a sweepstakes, where the class action plaintiffs alleged that there was a failure to disclose the free AMO or alternative method of entry, which was available. It was simply alleged that the failure was so great that essentially it rendered the whole sweepstakes misleading and deceptive, and effectively an illegal lottery. There's since been a ruling on the motion to dismiss. This is in California, where the court found that, in fact, there's not an illegal lottery, that a free AMO was available, but that the promotion could nevertheless have been deceptive and misleading. So we'll see what happens with that. But it's important to remember that if you have that free alternative method of entry, it's not going to be worth much if you're not disclosing it clearly and conspicuously. So in terms of your sweepstakes or your contest, there may be special considerations based on who your audience is, and that's important to keep in mind. If you're running a promotion just for your employees or your customers, some states specifically target in their sweepstakes laws only consumer sweepstakes. So you really need to worry about, in that case, only about following the lottery laws and making sure that you're not offering a criminal lottery. But you don't need to worry as much about following the specific ins and outs about, the sweepstakes laws and registration and bonding. Or you probably want to have terms and conditions that are very clear about how things work and the like, because you don't want to end up essentially with some sort of unjust enrichment or contract lawsuit, because of course any terms and conditions are a contract. But you may not have to worry about following the sweepstakes laws in the states that specifically focus on consumer promotions. That being said, not every state has a sweepstakes statute that's that narrowly drafted. And in fact, probably the majority don't, to paint that a little broadly. Don't hold me to it. But there may be special issues in employee promotions or trade or customer promotions that you need to consider. Whenever you're targeting your customers, and in particular the employees of your customers, you need to think about things like the commercial bribery laws, which can vary again from state to state, the joy of working with state laws. And, essentially say that if you are giving payments or promotions to customers or your employees' customers, you may be liable for that, essentially as, an attempt to switch your customers illegally. Often those have limitations, the payments have to be more than de minimis and the like. There has to be an injury. So it may be that if you're offering something where the prize is very small, it may not be an issue at all. And it may be that, as simple a matter as just getting your customer, meaning your customer who's the employer of these employees, getting their consent to participate. But it's just important to be thoughtful about that. And then again, to be thoughtful about what the terms and conditions are so that things are clear and there are no problems down the line with winner selection or that sort of thing. Promotions for your own employees, of course, there can be issues like compensation and tax, making sure that, the taxes are done properly. Or making sure that, it's clear that people should not be doing, if you're doing something like a skill contest or a sales contest, what the restrictions are in terms of people participating on work hours versus their own time. If you're asking for user-generated content, who owns the content that's produced? Is it a work for hire? It's just important to be thoughtful about that. I get the question a lot. Why are we, what is with the practice of excluding employees from promotions? Generally, that's about the appearance of impropriety as much as anything. Although, there is the issue of cheating. McDonald's ran a version of its Monopoly promotion years ago. It actually ended up being the subject of a show. Okay, I'm going to forget which cable channel, but it starred one of the Wahlberg brothers, where the contractor for the McDonald's Monopoly promotion fraudulently obtained some of the game pieces and then started distributing the winning pieces to friends and family. So this is why you often exclude employees, because of the problem of there could be cheating, there could be fraud, or there could just be the appearance that could happen. So, if you decide you want to include employees in a general consumer promotion, you need to go in with your eyes open and maybe consider excluding the people with direct access to winner selection or that sort of thing. With promotions targeting children, remember that there are privacy issues with this in particular. Through COPPA, the Children's Online Privacy Protection Act, which require parental notification and consent when collecting information from children. With the California equivalent, the California Consumer Privacy Act, which actually with COPPA, it's children under 13. But with the CCPA, the protections are extended up to 15, so that children 13 to 15 have to provide opt-in consent. So you'll have to ask, if you're allowing teenagers aged 13 to 15, you'll have to ask them for their opt-in consent to provide personal information, which of course is typically involved in sweepstakes and contests. Additionally, CARU, which is the Children's Advertising Review Unit, part of sort of the informal self-regulatory structure around advertising, requires disclosures when you're running sweepstakes for children in language children can understand. So things like odds disclosures instead of odds of winning are based on number of entries may look more like many will enter, few will win, or many will enter, one will win. And it's important to consider that. And then also the privacy issues, which they will enforce and also have a safe harbor program. Another interesting issue that comes up is the issue of discrimination and civil rights and how it sort of touches on promotions law issues. We're all familiar with state public accommodations and the civil rights laws, but the way it comes up here is if you want to run a promotion that is targeting a group like a women-only promotion or a promotion targeting minority groups or the like, it actually has come up in this context in things as varied as ladies' nights promotions or scholarships, or there was a promotion for Wonder Woman a couple of years ago where they wanted to have a female-only showing in Texas. It came up there. So to the extent that you want to target a specific group with a sweepstakes or contest, it's important to be thoughtful about what the risks are. There are multiple states who have these civil rights laws. And to the extent that, your promotion may involve a public accommodation, then you may have an issue there. And you want to be thoughtful. I mean, of course, the sort of public mood nowadays tends to be more in favor of a lot of, these the concept of, sort of a pro woman promotion, or like the Wonder Woman promotion I told you about, or I just mentioned. In fact, it ended up being that a man challenged the promotion, and then the mayor of Texas came out and said, "This is really silly. I can't believe you're doing this." And, the sort of social trend ended up being in favor, and the whole thing got dropped. But there have been lawsuits. I mentioned on this slide a California Supreme Court case that found a car wash ladies' day discount was prohibited. But, years later, 20 years later, there was a finding that, a gift that targeted women was fine. Some state laws do say that if there's a business justification for a promotion that targets a specific group, it's okay. But some states don't have that business justification built into the law. So it's important to keep in mind that this is out there, and go in with your eyes open, and sort of you may want to do the analysis before you decide that, yes, we're going to offer a promotion or a contest that allows only a specific group to participate. An issue that comes up frequently is the modification and termination clause. This is probably the thing I hear about the most. We didn't like the way our promotion went, and can we make a change? Can we extend the end date? Can we, it came up a lot, frankly, during COVID, when there was a real situation in many cases with impossibility, where, the tickets for a concert that were being offered as a prize, and the concert was canceled or the date was changed. Generally, whenever you change or propose to change the rules for a sweepstakes or contest, you need to keep in mind, A, the terms themselves, and B, fairness, deception, other consumer protection principles. Typically, when we draft sweepstakes rules, we build a lot of latitude in for discretion, for the ability to modify, and the like. But the reality is that unless you have a situation where there are real issues like fraud or, impossibility, like I just mentioned, it's highly inadvisable to change the rules. In fact, for quite a while, the New York Department of State, which is the one who takes the registrations, would reject rules if they had an overly broad modification clause. They have relaxed on that considerably, but like I said, you really want to watch any modifications unless you're in a situation where you feel like, gee, it's impossible, it's impracticable, per force majeure doctrine, which was raised a lot with the COVID-19 situation. You can get in trouble for this. This recently came up with a company called Artesian Build, which was a custom PC company, and this month it came up, that was offering frequent giveaways. It actually ended up suspending its business on March 10th. What had happened was it was making frequent giveaways to influencers, where it would offer relatively small prizes, typically, custom builds of its computers, to its influencers. Apparently, it was online on a live stream when it went to select the winner for one of these giveaways. And its CEO reviewed the winner's account during a live stream event and decided she was too small and did not meet the threshold requirements for the giveaway, sort of derided this winner and tossed it out, picked a new winner. What ensued was a social media storm, and he was criticized, ultimately apologized, but all of the ambassadors that were working with him quit. So there's been no legal action to date, but, watch this space. This is sort of a worst case outcome, but it's not, that could never happen, certainly in terms of the PR storm that ensued. It's definitely interesting that I imagine this company will reform, but they did give up the ghost recently. So certainly it highlights the importance of creating your rules and then following them in addition to posting them, because apparently as of this date, or we could find no rules online. Don't change those rules unless we're talking about, fixing typos, or as we talked about, this, impossibility, impracticability type of situation. Certainly don't throw out your winners because you don't like them. And this is something that I have heard on, a regular basis and advised against. Finally, if something goes wrong, apologize. Probably the better thing to do in this situation would have just been to award the prize. He gave her a discount, award the prize, pick a new winner as well if you didn't like the winner. But this was sort of worst case scenario for you. Skill contests and UGC. We talked about, we've talked mostly about chance here and the need for AMOE. But with a skill contest, the absence of chance means that, you may be able to have consideration because you've eliminated that chance element, except that there are a few states where even if you have, even a skill contest, you cannot have a purchase or payment. You can have non-monetary consideration. So, that's something to consider. In those situations, you may be able to come up with a workaround, but certainly in best results contests or product reviews, that may create a problem. Also, keep in mind that Arizona requires registration for certain contests where purchase or payment is required. Similar to sweepstakes, you need rules. You also will need, an explanation of how you're going to pick the winners, what's appropriate, who your judges are going to be. And then we'll talk a little bit about, to the extent that you are soliciting user-generated content, there are additional considerations here. With user-generated content promotions, there's the traditional, submit your photo or video and you will be entered. There's also things like open submission programs where there's not necessarily judging, but just everybody submit content. And we will pick the ones we like best. So, a little different from a content, or there may also be crowdsourcing programs where you sort of try to come up with one result with everybody's help, hackathons, sort of somewhere in that as well. With all of them, you need terms and conditions. With all of them, similar risks in terms of you may be surprised by the outcomes you get as well. So you want to provide for that in your terms and conditions as well. In addition, you need to comply with the contest laws, and you need to keep in mind some of these intellectual property issues. So we'll talk about that now. Keep in mind that users own any original content that they post on social media. The social media platforms don't give you, as a commercial entity or commercial sponsor, any particular rights to repost user or third-party content. People are allowed to repost, but they're allowed to repost in sort of their consumer hat. It's questionable whether they can reuse for commercial purposes without first getting the consent of the original poster. There are three types of IP protections or third-party rights we're talking about here. Copyright, which goes to video, images, photographs, trademark, so company names, company logos, slogans, the right of publicity, which goes to people's name, voice, likeness, image, and also not just the person posting, but third parties. So you need to take all those into account. With copyright, the platform owner is protected, and people like to claim fair use, but to the extent that you are planning to reuse this in any way for commercial purposes, including in the contest or in your advertising, you need to take a close look. Generally, we say with this type of content, if you are planning on social media platforms to simply allow people to post in their feed, on their own page, in an Instagram feed, on Snapchat, on their own TikTok, then that's okay. But if you plan to repost on your website, retweet it, repost on your own Facebook page, then you're going to sort of step into some risk when it comes to copyright, trademark, that sort of thing. So that's when you want to be careful and start to think about getting the rights. Additionally, you want to be very careful about sort of what we call dangerous trademark owners, whether it's the NCAA right now, the NFL, these trademark owners who very carefully protect their trademarks. And if they see you reusing them, even if it's in a third party's content, will be sending you letters saying, please cease and desist. So if you plan to reuse them in third parties' content, I would suggest blurring them out. Or if you want to use it in your own original sweepstakes or contest, either use something generic like the big game for the Super Bowl or get permission. So in terms of getting consent to reuse user-generated content, generally in a sweepstakes or contest, we recommend doing two things. First, include clear terms in your sweepstakes or contest rules that say if you send in an entry, then you will be giving some limited permission, particularly if you plan to sort of post all the entries on a website, for us to use the intellectual property in that user-generated content entry. But then with respect to the winners, having the winners sign a release that will give more extensive rights. The advantage of having that release signed is that, particularly because you're offering a prize, the release will then be supported by consideration. And so it will be, sort of a signed, sealed, and delivered intellectual property release that will, most assuredly stand if there's ever a challenge to any kind of use. To the extent that you find somebody's user-generated content online, or if you have an entrant who maybe isn't the winner, but you want to use their UGC nonetheless, you can ask them via social media, contact them, say, I love your content. Will you give us permission to use it? Generally, just having somebody respond yes to, will you let us use your content is a little overbroad. But if you make that a specific request, ask them to respond using a hashtag or something, I agree, then that's better. Even better, hyperlink terms and conditions or some sort of release to it. And that will really make it, much closer to airtight on that sort of thing. Remember as well that to the extent that people are participating in a sweepstakes, or they are in some way being compensated for use of their content, you need to have them disclose the receipt of compensation, or even something as little as a sweepstakes entry under the FTC's endorsements rule. So having them say something like hashtag sponsor sweepstakes, or hashtag paid, or something like that, will also cover you off on that. In terms of then UGC best practices, we've talked about most of these, but the idea that you would get, participants to accept the terms of the sweepstakes or some release, have clear submission guidelines in any UGC contest, screen the entries you're getting so you make sure that nothing that's going to embarrass you is going up on social media, and then have these reps and licenses and the reference to signing a winner agreement in the rules, as well as a grant of publicity rights and intellectual property rights, things like that. You may also want to consider a background check for the winner. I'm dropping a little behind, so I'm trying to speed up here. We started a little late, so we may run over just a little bit. With social media promotions, I mentioned each platform has its own rules. So it's important to keep that in mind whenever you're running a promotion on a specific platform. The consequences being that your promotion may be pulled down if you don't follow those rules. So it's important to keep that in mind. If your promotion is pulled down, you're not going to be able to run it to the finish and award all prizes, and you may end up in violation of state law. Keep in mind, social media creates heightened awareness, and, the backlash, if you do something wrong, may be all the broader. So Facebook and Instagram have a lot of rules. Some of the basics are, Facebook is probably the most restrictive. Some of the basics are listed here. We mentioned the requirement to include releases for the platform, as well as remember that you can't do what's called like gating a promotion, which is a requirement that people like your page to enter. You can ask for people to like a comment or a picture, or something like that. That's probably the most misunderstood rule even today on Facebook. So keep that in mind. Instagram, the rules are very similar to Facebook, not surprising, with regard to things like releases and the like. Another thing to keep in mind with both platforms is you can ask people to tag people in comments or in photos, but you can't ask them to tag in photos inaccurately. So something to keep in mind there. Twitter promotions, the thing that were probably the newest rule and the thing that people probably have the greatest problems with right now are the automation rules. Twitter's biggest focus is they don't want spammy promotions. They don't want people kind of encouraging multiple tweets per day, retweet to win promotions, and automated rules. So if you're asking people to tweet the same thing over and over as part of a promotion, or multiple people to tweet the same thing, be careful there, because you run an increased risk of being shut down. Limit people to one tweet per entry, or one entry, or at most one tweet per day. And then watch sort of that repeated tweeting of the same comment. With YouTube, the big thing is that your official rules must require including links to YouTube's community guidelines. You must comply with YouTube terms of services. You must include a privacy policy, and then you've got to have those releases for YouTube as well. You also can't manipulate YouTube's metrics. So things to keep about here. LinkedIn does not allow promotions on their platforms right now. So keep that in mind. And again, no spammy promotions for Snapchat and Pinterest. I'm going to leave you with these sort of key restrictions here. But, keep in mind that you do have to follow these rules. I'm always happy to disclose these, to discuss these if you have questions about specific platforms. We discussed the FTC endorsement rules, disclosure requirements, but the key thing is the idea that if you're running a promotion that is asking people to sort of post online, you need to, and then you need to include that hashtag company sweepstakes or hashtag contest entry or something like that. Additionally, employees need to disclose their connection to the company if you're asking them to post online or if they're posting online. Reviews have also become a really important topic to the FTC. So if you're running review sweepstakes, they need to be disclosing as well, with the hashtag sweepstakes, hashtag, that sort of thing. So be very careful if you're asking people to review. There's a lot of very misleading review practices going on right now. I just got a card today from somebody I bought a product for on Amazon saying, review us, but don't post anything about the fact you're getting this free gift card. And I'm like, okay. Refer a friend promotions. all prize promotions with refer a friend component should be vetted for can spam compliance, because can spam may be triggered whenever you're offering an incentive, like a sweepstakes entry or coupons or points in return for forwarding a commercial email. So, this means that you can't have false header information or misleading subject lines, and you must have the opt-out, and referred friends must be vetted against your internal do not email list. There are ways to work around can spam depending on whether it's the individual sending the email, or the company's, refer a friend structure. But it's important to look carefully at how it's being structured to make sure, that it's a real, I'm sending the email, or the sweepstakes sponsor is sending the email, and whether that's really going on, because sometimes, sometimes it's not all as it immediately seems. Text promotions, we have seen some promotions now, or some lawsuits now that involve promotional sweepstakes and text messages. So, I think we're all familiar with these class actions that involve very large settlements due to violations of the TCPA. So now there have been some class action plaintiffs who have brought TCPA class actions involving unauthorized text messages sent in connection with sweepstakes. If you are running a text message sweepstakes, make sure that you are complying with the TCPA and involving, if you propose to obtain consent to send text messages above and beyond like the initial sign up that, yes, text to enter, make sure you've got those appropriate disclosures. There's also the well-known cases involving American Idol and Deal or No Deal, where entrants were being encouraged to text in order to vote for their preferred competitor, and ultimately the class action involved premium text messages, and an allegation that the premium charges that the sweepstakes entrants were being asked to pay were consideration, or alternatively a wager in violation of Georgia and California law. Ultimately, the case in California in particular, I think Georgia, they found it was not a wager under the Georgia law, and in California, the case ultimately settled. I think that there's general agreement that a premium text message is likely to be deemed consideration. However, whether a standard text message is consideration still has not been addressed by the courts. Some attorneys general have indicated they think it probably is. So be careful. You may want to simply include a free alternative method of entry. I'm going a little over here. This will be taped if you can't stay on. If you can, thank you. I appreciate your continuing to listen. Non-fungible tokens and crypto. We're seeing an increasing use of NFTs and cryptocurrency as prizes in sweepstakes, which that may trigger additional issues. Starts with the need for clear definition of terms, of course. So NFTs are non-fungible tokens. But then there's some additional issues here. The first is that, of course, a requirement to purchase a non-fungible token or crypto may be consideration. I think that was probably pretty clear and may trigger the lottery laws. So there may be some fees involved here that people may not initially see. There may be fees in opening a wallet. I recently saw a sweepstakes where there was a proposal to award money in an account where there were fees that you had to download an app, and there were fees involved in maintaining the account, but not even if you didn't have to pay any fees to open a wallet. So it's very important to thoroughly vet the app, any accounts you're required to open, sort of any thoroughly vet the structure of the sweepstakes and any associated apps, wallets, et cetera, et cetera. In addition, it may be that there are fees. You decide to provide a free alternative method of entry, but as we talked about, you must clearly and conspicuously disclose that free alternative method of entry. In addition, NFTs are unique and one-of-a-kind digital files. They're a little bit of intellectual property that you purchase and you may hold. And so there, of course, are intellectual property considerations involved there. Generally speaking, the NFT is not reproducible in any way. It's just a little, there's copyright issues here. And it's very important that you both define what an NFT is and define exactly what bundle of intellectual property rights you get when you win. You have to assume that most of the entrants in your NFT sweepstakes or your cryptocurrency sweepstakes do not exactly understand what they're getting. So it's very important to be very clear, and then whoever the winner is, to make sure that they get very clear documentation that explains exactly what they can and cannot do with that bit of intellectual property. In addition, with either cryptocurrency or an NFT, the value may rise and fall over both the course of the sweepstakes, and then at the time what they get may be different in terms of approximate value than the way it was announced at the time that the sweepstakes or contest was first announced. So how do you deal with that? In general, what we've been doing is sort of announcing, of course, the general concept of approximate market value or the like has been approximate traditionally. So, you may wish to announce it as just that. The value as of X date is Y, and it may change over time. And then again, at the time it's announced the value again. But certainly your disclosures, again, need to be very clear. Additionally, there may be, particularly for cryptocurrency, we're still working on it with NFTs, certain securities related disclosures that may need to be disclosed. Finally, NFTs, generally it's believed that NFTs don't have any value on the initial market, and their value is determined based on essentially resale on a secondary market. So that presents some interesting issues as well, and they're still sort of being worked out. There are also some interesting issues. We're seeing these NFT exchanges, and NFTs are numbered. There may be certain ones that are signed or have different characteristics. So there's some interesting issues as to whether there's chance inherent there. We may, look to certain cases about trading cards or loot boxes or the like for some guidance there, but I think we're going to see some increased developments as to, what NFTs are, whether there is any chance involved in NFTs generally, and that'll continue to develop. There's also, that may wind back into NFTs. and the trading card concept, because we are seeing these NFT trading cards. The same with esports players, traditional sports players. We're seeing these trading cards being sold on exchanges. Again, you've got these licensing and copyright issues. And chance issues. So that's sort of a developing area. In general, esports, which is, basically a skill contest or competition, is another area that involves, contests or chance. That's really a game of skill. It's another one of the areas that you see as sort of an exception to the lottery laws, because you've removed chance out of the mix. They're an increasingly well-organized form of skill competition that we're now seeing being played at the professional level, often with entry fees involved and sponsorships. To the extent that you have any chance in the mix, you may run into illegal lotteries. But in general, if you allow it to be strictly, or if you make sure it's strictly a skill competition, then you're going to be okay. The key is to ensure that those entry fees aren't converted into illegal bets or stakes or wagers under state or federal anti-gambling statutes, and instead that you make sure that it stays a legal skill competition. There have been interesting issues with regard to skins, which are virtual tokens such as guns or potions or swords that help players play or advance in esports. And generally, again, have been permitted, even though they're purchased in esports or similar competitions. But there have been some issues that have come up over time, to the extent that betting has sort of moved into the skins area. Generally speaking, in the primary markets, we haven't seen betting, but the companies that are involved in esports have had to police the market for these skins very, very carefully to make sure that skins have sort of stayed as, there hasn't been active betting in the primary markets, and then they've tried to keep betting out of the markets to make sure that they don't inadvertently walk into some gambling issues. Surprise and delights. Just a quick note about that. We hear everything is a surprise and delight nowadays. But the key here is to make sure that a surprise and delight is a promotion where something is being given away, but it's not being advertised in advance. If you're advertising something being given away in advance, then you need to look at whether it's a sweepstakes or contest. If not, then you may be able to argue that it's a surprise and delight, and therefore you don't need terms and conditions, which is why they're so attractive to marketers. The idea is that, if I pick my 5 current best customers on Facebook and I give them something, then maybe they'll talk the company up without my having to go to the bother of writing lots of terms and conditions and maybe registering and bonding in Florida and New York, or otherwise complying with all those complicated sweepstakes and contest laws. But if I talk it up by saying, hey, come to Facebook and you may win a really, neat trip or something like that, then, you move back into sweepstakes territory and you've got to worry about writing terms and conditions. So the more you talk about it in advance, the more likely you're going to trigger all, the legal disclosure requirements. The more regularly you do it, the more likely customers are going to start to expect you to be doing it. And so, you've got to look at whether this is something that is just sort of a one-off or maybe an every so often, or whether it's something that really is a promotion run on a regular basis or a pre-announced promotion. Additionally, if you are giving something significant to people or suggesting they talk about it, then you may be triggering the requirement that people disclose the receipt of something of value under the endorsements and testimonials rules from the FTC. So, maybe give it to them and say, gee, we don't ask that you talk about it. You don't have to, we don't suggest that, you don't have to say anything good or bad or otherwise, but if you do, please disclose that you got this for free from us. Charitable promotions. Very popular. I mentioned raffles briefly. Sorry, just rolled around there. Sweepstakes run by nonprofits or commercial entities working with nonprofits are increasingly popular. Raffles or commercial, this is different from raffles or commercial co-ventures run by nonprofits. Or raffles run by nonprofits, which are very limited and can only be run by by nonprofits, or commercial co-ventures, which are subject to a different set of laws. And I'm going to leave for another session because they are extremely difficult to comply with. Well, they are extremely separate and often difficult to comply with. But what we're seeing a lot more of are charitable sweepstakes, either run by nonprofits or commercial entities working with nonprofits. So platforms like Privzio or CharityBuzz or Omaze, where they're giving away something, and instead of complying with the raffle laws, they offer the free alternative method of entry. Florida has a law that provides an explicit exception for nonprofit sweepstakes to the lottery laws. From there, it's a lot less clear whether this is an exception because most states have, specific promotional sweepstakes laws. The California Attorney General a few years ago brought a series of investigations, sent cease and desist letters, essentially based on the failure by the commercial entities it was initially triggered by the failure to file under the professional fundraisers laws or to maintain registrations under the professional fundraiser laws. Ultimately, the settlement really had more to do with the failure to disclose the free alternative method of entry clearly and conspicuously. So it's important to keep in mind that there are separate requirements here, that it may trigger the professional fundraiser laws, and that these requirements are distinct from commercial co-ventures or raffles, or even, auctions, which may be regulated by state auctioneer laws. So to the extent you're getting into this area, you need to be thoughtful about, all of these laws and the fact that they impose different regulatory requirements, and they're not just sort of, oh, well, now we don't have to comply with the promotional sweepstakes laws. So final slide, international considerations. I often either get questions about, can we just run this in every country? Or aren't all the laws similar? We're all online nowadays. Many companies are multinational. It's important to keep in mind that the laws can in fact vary significantly from jurisdiction to jurisdiction. And so if you want to operate your sweepstakes or contest in multiple jurisdictions, you need to keep in mind that there can be translation requirements, there can be registration requirements, more commonly for sweepstakes, but also for contests. Brazil, in particular, requires both sweepstakes and contests to be registered. Multiple countries require translations. Europe, Asia, generally we recommend translation into 5 or 6 languages if you're going multinationally. Some countries prohibit cash awards. Some have specific requirements or prohibitions when it comes to asking for the intellectual property rights in entries if you want to run a user-generated content contest. Some require or prohibit specific kinds of prizes. Canada actually, interestingly, Quebec relaxed some of its registration requirements, but still has a translation requirement. So, and then there are just the kooky things, like we worked on a multinational charitable promotion with a company and found out that Africa has laws requiring soliciting or regulating soliciting alms that in this case, it was an employee contest where the employee was allowed to donate money to the charity of their choice. And this created problems. So, like I said, very kooky requirements that can really surprise you sometimes. But if you're a large company, you don't necessarily want to find yourself, when you're trying to do good, getting a black eye all over Africa. So it's important, if you're doing something, particularly something that's going to be high profile, or where you're giving away a large amount, something like that, to take into consideration the risks that are inherent in running a multinational promotion. It may be that ultimately, if you're running something that's online only, where you're not targeting residents of specific countries, that you decide that, well, it's not a high risk. But you do need to take that into account and do the analysis before you open something up to multiple countries. It's relatively simple nowadays to simply say limited to residents of the US and geofence. So, it's not an excuse to just plead ignorance. This is particularly true when the privacy law risks can be just as great as the risks inherent in opening a sweepstakes up to multiple countries. So we have a lot of questions. I'll maybe pick a couple, and then we will close this off at 3:30. Well, I'm really hot on the right to modify. So I have one regarding including the right to modify in official rules. Isn't this generally not a good idea because it would result in unfair treatment of entrants prior to modifications? That's absolutely right. That's probably the number one reason not to modify rules. There are a ton of cases out there that involve, lawsuits where a litigant has sued because of unfairness due to a modification to rules. So private litigation, as well as regulatory cases that were brought after a modification due to unfairness and deception. So that's really the primary reason not to modify. Is this concept of unfairness and deceptive, conduct due to a modification. Does the retail and bonding requirement in New York and Florida for prizes over 5K only apply to retail commercial sweepstakes and not to nonprofits? That is correct. As I mentioned, Florida has a separate law for nonprofit sweepstakes. And New York will just registers nonprofits under the Charitable Gaming Board and will kick anything back for a nonprofit sweepstakes otherwise. So sorry, there's a lot of questions. So some of them are sort of in process and a little tough to interpret. Okay, there's a question here about, since I didn't cover Facebook as much, can you clarify the slide on Facebook promotions that sweepstakes can't be promoted on personal pages? Facebook does have a rule that you cannot incentivize promotions on personal pages. So that's one of their rules. Essentially, they want any promotion that you're running to be run on the brand's page. So to the extent that you say, hey, post a picture on your page, and you will be entered to win X. That is in violation of Facebook's rules. It's not in the promotions rules. It's in, I believe, the developer rules. So that's important to keep in mind. It frankly results in a sweepstakes that's much harder to track for you as the sponsor. But essentially, I believe there's an example in one of the blogs too that says sort of this, not this. It applies not just to sweepstakes, but to any incentivized promotion. The idea that you cannot incentivize any promotion that requires sharing on personal pages. So if anybody else has questions, feel free to post. We have a question: what does at retail mean for Rhode Island registration? Generally, Rhode Island's registration requirements apply to sweepstakes that are run with some in-store component. They're less interested if it's sort of online only. The nice thing about Rhode Island also, because of course we all have gotten those requests for last minute registrations regularly, Rhode Island takes a registration pretty much any time. Risk of sweepstakes among a company's own employees. I talked a little bit about this. The risk of the sweepstakes among a company's own employees, they're generally lower risk, but it tends to be primarily about the taxes. A prize is generally part of compensation, making that clear, and then being very clear about following the labor law issues. So to the extent that you've got an hourly employee, they should only be participating on their time, on their own time. And then to the extent you're asking people to produce content rather in a contest, is it work for hire, addressing the IP issues, and then just having very clear terms and conditions. The other interesting thing that came up was we saw a lot of these vaccine sweepstakes. And I believe there may be some that are still being run to incentivize people to get vaccinated. That, of course, can raise some interesting issues as well in the employee sweepstakes context. So it's important to coordinate again with your employment lawyers and make sure that you're not, you're not violating any rules on that side of things. And you're following any company policies on that side of things. So, something to consider about that. So I think we're at 3:30. I'm gonna close this off and thank you all for attending. And I completely forgot. I am so sorry to give you the CLE code. That's a way to get everybody to stay. It is contest 2022. And I really apologize for that. But thank you so much for attending. It's really always fun to do these presentations. And if you think of a question later, please do email me. I'm at mlsteinman@venable.com. Have a good afternoon, everyone.